Welcome to our latest session on employment law basics. This is aimed at startup and entrepreneurs. Just a few housekeeping bits and pieces before we get going. If you can just all make sure you are on mute for it. And if you have any questions throughout the session, just feel free to pop them in the chat box. And if we can address them there and then, we will. And if not, we might have some time at the end to look at that. So my name's Sam. I'm one of the solicitors here in the employment team. And I'm joined by my colleague, Tom Hyatt, also a solicitor in our employment team, for this session. There we are. So just a couple of initial slides about the firm and what these sessions are aimed at. So Harrington Carmichael, as it says here, is a full-service law firm, and we can assist with most needs. And there's a bit of details there about some of our recent awards and bits like that. So the WISE sessions, WISE stands for Wednesday Insights for Startups and Entrepreneurs. And what we want to do is give these sessions for small businesses or individuals who are looking to start their business or have maybe recently started on that journey, give them knowledge and information to really help them underway. And here at HC in our Farnborough office, we have space, which is a free office space for entrepreneurs and startups to use and utilize. And this is just a resource that is provided as part of that. So with that in mind, let's get underway with our actual session today. So as I said at the start, this is looking at employment law basics and is really aimed at startup and entrepreneurs. So perhaps you've recently taken on your first employees, or aren't even at that stage yet, but it's something you know is down the line and you're looking at. What we're going to look to cover here is essentially giving you a general overview of some of key employment law topics, things you need to understand as potential employers, the legal framework we have in place here in the UK as part of employment law, and why it's important to have that compliance. So on that, the first topic here is employment law and why is it so important for us? Employment law is the foundation of the employer and employee relationship. It looks to give protection to both parties. So this isn't all about, being able to protect an employee or what's best for an employer. It's a two-way thing, the employment law, and it protects both parties, ensuring fair treatment and compliance with whatever the necessary laws and regulations are. Understanding the employment laws as you're joining the world of being an employer is really important, because getting it wrong can just cause issues and disruption for a business, especially as a new business. If you ended up in a legal dispute with a potential employee or facing costly litigation, obviously that's not ideal as a startup or for anyone for that matter. And compliance with the necessary laws can also ensure you have a fair, productive work environment, which naturally will help with productivity and your success as a new business. So where does our employment law come from? So we have some different aspects which really build up what is the UK employment law. So we've got statutes, so this is legislation and laws. The two key pieces really that we focus on here is the Employment Rights Act and the Equality Act. And we'll be touching on various aspects of those as we go through this. We also take aspects of our law from common law. This is law that's derived from court cases and employment tribunal decisions. And then there's other things that can influence it. So EU directives, albeit we're not sat in the EU anymore, our laws will still be influenced by them. And there is aspects of EU law which has been retained. But it's always changing employment law, so you need to always be up to date on it to ensure you're not falling foul. So I'm now going to hand over to my colleague Tom. Tom's going to start by looking at employment status, but I won't say anything more on that and hand over.
Brilliant, thanks Sam. Let's get stuck in. So we're going to look at employment statuses to start with. Broadly, three types of employment status. Including self-employed, so somebody who doesn't have employment status. It's important to understand an individual's employment status because it's their employment status that determines what rights they have and what their obligations are towards their employer. Looking at the first status of employee first up, so around 40% of the people of the population of the UK are employees. So that means they have employment status. So an employee is someone who works under a contract of employment. And this type of relationship is determined by three key tests. Firstly, personal service. So is that employee required personally to work for their employer, or could they send somebody else in their place? If that employee can send somebody else to work in their place, it might not be an employee, because that would be unusual for someone with employment status. Next up is mutuality of obligation. So is that employee obliged to accept work, and is their employer obliged to offer them work? Without mutuality of obligation, it's unlikely that somebody is going to have employment status. And lastly is the issue of control. So how much control does the employer, the company that the employee is working for, have over the individual? Can that company determine how, when, and where that work is provided? Now, probably thinking, well, in most cases, yes, employers can. So typically when someone has employment status, there'll be a reasonable degree of control the employer has over their employees. So if all of those three tests are met, then an individual is likely to have employment status, and as a result, they would have the all of the rights that are set out there, in addition to all of the rights that a worker would have. Now, a key difference between the rights that an employee has and a worker has is the right not to be unfairly dismissed. Now, after 2 years of service, employees have far more comprehensive employment rights than somebody with worker status, because they cannot be dismissed without there being a fair reason to do that, or a legal basis to end their employment. Looking at the status of worker next. Now, worker status is generally a lower threshold than employment status. Worker status generally captures individuals who may not meet all of the thresholds for being an employee, but there is still a requirement for personal service and a degree of control that the company that engages them has over them. A key distinction between someone with worker status and employee status, generally mutuality of obligation. So generally under someone who is a worker is not under an obligation to continue accepting work from their employer, and the company that they provide services to is not obliged to continue offering them work. So typically we see someone with worker status in a casual worker relationship, a 0 hours contract where someone's not obliged to commit any number of hours, and equally the company they work for is not obliged to offer them shifts or patterns of work. You see employment status typically with agency workers as well. Sorry, you see worker status even with agency workers. You will have agency workers that meet the threshold of being employees, but it's less common. Typically, someone who's an agency worker would have the rights of a worker. And last but not least, self-employed people. People who are self-employed run their own businesses, and they shoulder both the risks and rewards of that business. Now, unlike employees or workers, self-employed individuals aren't paid through PAYE. They don't have the same rights and protections. What's the trade-off? Obviously, greater flexibility and the potential for working for multiple clients at the same time. They equally have to manage their own tax, national insurance contributions, and don't have the same access to employment rights like a employee or someone with worker status would have. Now, there are some limited rights that someone with self-employed status has, as set out on the slide there. You can see there are some protections against discrimination and protections for their health and safety, but generally far fewer rights and protections than someone with either worker status or employee status. So why is it important to understand this? Well, it's critical for both employers and employees to understand the employment status of people that are working for them or with them, because if you were to get it wrong, it can have legal, financial, and tax implications. And getting someone's employment status wrong can lead to disputes, penalties, and potential payments having to be made to them later down the line. Now, employment status is something that the government has focused more and more on, I would say, in the last few years. Now, some of you may have followed the news headlines around Uber and Deliveroo. These were cases where the likes of Deliveroo and Uber were labelling people that worked for them as self-employed, but the reality was these people that were working for Uber and Deliveroo met the tests for worker status. So they did in fact have worker status. Now this came to light when those individuals started bringing claims for worker status, because understandably they wanted holiday pay and sick pay. And you can obviously imagine that this ultimately ended up in Uber and Deliveroo having to acknowledge that they had worker status and then pay the additional rights and obligations that they have to for worker status, the key ones there being holiday pay, pension contributions, and statutory sick pay. Sam, if you could move on to the next slide, I'm just going to talk a little bit more about actual employment contracts. Now, I'm not going to be looking at worker status or self-employed contracts here. It's obvious that somebody's status needs to be reflected in whatever contract they are engaged through. Self-employed persons would typically be engaged through a consultancy agreement or a contractor agreement, and casual workers, 0-hour workers, will have their own worker contracts. But I want to look at and focus really on this side, employment contracts, so for people that have employment status. Firstly, key elements of an employment contract. It's a fundamental principle of contract law in the UK generally. There needs to be an offer and that needs to be accepted. And that equally applies to employment laws. There needs to be an offer of employment and that needs to be accepted. And it's this mutual agreement that initiates the employment relationship. So looking at the employment contract, there is certain information that needs to be provided to all employees. There's a statutory obligation to provide certain information, and this includes your common bits of information such as job title, pay rates, holiday entitlements, whether there is a probationary period that applies to the employee's employment. Typically, though, employers will want to go beyond the bare minimum that they're obliged to provide, because it helps protect them and also set out exactly what is expected of the employee. Looking at the contract, express and implied terms, what does that mean? What are they? So express terms are written contractual terms. We'll look at those in a little bit more detail on the next slide, but these are terms that are stated clearly in the contract, in writing, and that's where you would expect things like job title, pay, and working hours to be set out in the contract. Implied terms. Now, what are implied terms? Implied terms aren't written, so they're contractual terms, but they may not be set out in the contract. But they are understood to exist. Now, these may cover duties such as trust, confidentiality, and again, I'll look at that in a little bit more detail on the next slide. Moving on to custom and practice, what do we mean by that? So practices that can become part of the contracts over time. If an employee is treated in the same way consistently, and we are subjecting them to certain employment practices, then that can become a contractual term if it's consistently applied to them. Now, look, generally, this is quite a high bar. It's not going to apply to every practice that is consistently applied, but it is certainly possible. And I think a common example where we see this happening is something like a bonus. Although a bonus may be expressed as non-contractual, i.e. someone doesn't have a right to keep on receiving a bonus, if they are consistently receiving bonus either in the same way or calculated in the same way over a long period of time, it's quite possible that can become a custom and practice term or an implied term in their contract. It becomes an expectation that they're going to receive that. So just something to be aware of. Where there are consistent practices, it is possible for them to become contractual obligations as well. To touch on variation, so changes to the contract need to be agreed by both parties. It's very difficult for an employer to change any terms of an employee's contract without agreement from the employee, and changing it without that is likely to amount to a breach of contract. Just a special note on verbal contracts. While employment contracts can be verbal, and a verbal employment contract can still be binding, it can obviously cause problems for employers later down the line, not only because of the obligation and there is certain information that needs to be provided to employees, but it also makes it very difficult to determine actually what are those contractual terms if we're relying on verbal contracts. So I just wanted to flag it there that they can exist and they can be enforceable, but it's never something to be advised. And wherever we're in a situation where we have an employee without a contract, we want to really address that pretty quickly and get some written contractual terms in place. Zero-hour contracts, I mentioned this earlier in the context of worker status, and it's something that is far more common with someone who has worker status. You'll hear zero-hour contract referred to in the media, and it has attracted also a bit of a negative connotation over the last few years because it suggests that people don't have employment rights. Now, zero-hour contracts can be used where somebody actually has employment status, although it is less common because it's more difficult to show that actually there's an ongoing obligation to provide that person with work. But I just wanted to discuss briefly that. And lastly, on this slide, just a note on staff handbook. So in addition to contractual terms, there are other policies that employers and yourselves may want to put in place that you may want your employees or soon to be employees to comply with. These are typically going to include policies such as disciplinary procedures, grievance procedures, health and safety, working from home policies, social media policies, the type of things that you want your employees to comply with, but we're not going to set out in an employment contract. So it's not recommended that staff handbook policies are made contractual, and we don't suggest that they are included in the employment contract. There's a couple of reasons for that. Although we may want our employees to follow that, it can be more burdensome if employers are bound to always follow those policies, but more importantly, can make it far more difficult to amend and vary those policies as and when we need to if they are set out in the employment contract. So just a point to remember there that often there's going to be additional policies that we want our employees to follow. We're not going to go to the extent of putting them in the employment contract when we can request our employees follow this as a reasonable management request to say, here are your policies in staff handbook, which we expect you to comply with. Just turning over to the next slide. So I'm not going to take you through all of the express terms. There's some examples there of the type of provisions you would expect to see in an employment contract. Obviously, some it will vary, specific to someone's job, the exact duties and what we expect from them. That's a fairly comprehensive list of the most common sort of provisions that you would expect to see in an employment contract. And what I want to take a minute to talk more on is the implied terms, terms that aren't necessarily written into a contract. One of the most fundamental implied terms is the duty of mutual trust and confidence between employers and employees. Now, this underpins the entire employment relationship, and it ensures that both parties act in a manner that doesn't undermine or destroy the employment relationship. I'm going to let Sam talk a little bit later on this about what happens if that clause is breached. So if the obligation, the implied term of mutual trust and confidence is breached, and he can talk a little bit more on what the implications of that are. Another implied term I'd like to touch on is the duty of care. Employers have an implicit obligation to provide a safe working environment, whilst employees are expected to perform their duties with a reasonable level of care and skill, which is not something you'd expect to see written in the contract, that the employer is going to provide a safe working environment. But it almost goes without saying that there is still an obligation. It's an implied obligation in an employment contract for employers to do that. And lastly there on confidentiality. Now, yes, there is an implied duty in respect of confidentiality for employees. So there's an implied level of confidentiality that employees have to comply with. But the reason it's on that list there, and the reason I want to flag it, is it's a very low bar. Confidentiality is an implied term. It's limited only really to trade secrets. So without express and written obligations in relation to confidentiality, all that an employee is required to keep confidential would be trade secrets, which in itself is quite a high bar as to labeling something a trade secret or not. So in reality, it can be very difficult for employers to rely on simply an implied obligation in respect to confidentiality. And it's for that reason, it's a term that you would want in writing to go far beyond just limiting it to trade secrets, so that we know what we expect from employees with regards to confidentiality. So look, I could talk for hours on employment status and contractual terms expressed and implied, and also staff handbook policies. But I wanted to give just a bit of a concise summary and an overview. And I'm just going to hand you back to Sam now to talk through some of the next few slides.
Lovely, thank you for that, Tom. As Tom said, all these topics really we're covering, we could go on for hours about, and this next one, discrimination equality, is certainly one of those. It's worthy probably of a multitude of different webinars to cover it, and even then we're probably only scratching the surface of a lot of it. But nonetheless, it's a really important aspect to be aware of as an employer. So discrimination in the workplace can have really serious legal and ethical sort of consequences. And it's really important for employers to have that diverse and inclusive workplace while avoiding sort of discrimination pitfalls. So we have sort of the key bit of legislation covering discrimination, which is the Equality Act 2010. And under the Equality Act, we have a number of what we call protected characteristics, which it sets out. Now, these are age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion and belief, sex and sexual orientation. So there's a whole host of protected characteristics, and what they are characteristics which are essentially you're protected from by way of sort of a discrimination legislation. When we're talking about discrimination, though, it's like, well, what exactly is that? And it covers off, there's various different types of ways discrimination can arise. So the first one is direct discrimination. Now, this is where an individual would be treated less favourably than another person because of their protected characteristics. So perhaps someone's being treated less favourably directly because of their age, for example. Indirect discrimination is where, as an employee, you might have some form of policy, a procedure or practice in place that applies to everyone, so you're not singling anyone out in particular. However, that procedure or practice puts certain individuals or certain groups of people with that who share a protected characteristic at a disadvantage. We then have harassment. So harassment from a discrimination perspective is where there might be unwanted conduct relating to a person's protected characteristic that violates their sort of dignity or creates an offensive environment for them. So that could be something, be it sort of some form of hate speech from a racism sort of perspective, or anything like that, or comments about someone's gender, perhaps. That could all amount to sort of harassment. And then finally, victimization. Victimization is where someone's treated sort of unfairly and less favorably because they've made a complaint about discrimination. So they might have maybe started the claim, or they might have reported the fact they feel they've been discriminated against. And then off the back of that, they're then treated sort of in a detrimental manner. Okay. And so one final one to mention as well is, as an employee, you would have a duty to make reasonable adjustments in certain circumstances. So, for example, if we've got a disabled employee who's put at a disadvantage because of something at the workplace, you've got a duty to make a reasonable adjustments to essentially help them overcome that and be able to sort of continue in their role. A really basic and easy example might be to do with accessibility, perhaps putting in be it a small ramp into the building because there's only stair access or something like that. But there's all sorts, and it covers off such a wide range. So they're the sort of types of discrimination and what can arise. But what we can also look at here is promoting the equality, diversity and inclusion. And naturally, in doing so, that can help avoid discrimination. So equality is making sure that all individuals and groups of individuals are fairly treated and no one's being sort of treated less favourably. Diversity, we're looking at recognising and respecting, sort of valuing everyone's differences as individuals and promoting a sort of inclusive culture. And naturally, in doing all of that, we're going to be ensuring that a fair approach is being taken and it helps avoid sort of discrimination. You can be doing things such as making sure your employees are aware of any sort of diversity and inclusion sort of policies you might have, or be looking to introduce as an employer, and also perhaps even undergoing training on this topic. The reason it's all important, is it's the moral right thing to be doing. We shouldn't be discriminating against people. And if you were to do so, there's also serious consequences from it. Okay. Firstly, there's obviously the legal action that can arise from discrimination. And you can be looking at essentially employment tribunal claims with uncapped levels of compensation, obviously dependent on seriousness of the claim, and the discrimination will depend on quite what the value of that is, but there is no cap in it on it. So that's not something you want to obviously be looking at. And as I touched on earlier, any legislation, any sort of legal disputes coming out of discrimination or any other employment sort of law topics at any stage can be so disruptive. So they're not ones you'd be wanting to be having to deal with. We also have reputational damage. So if you were to either have a sort of employment tribunal claim commenced against you, that's public proceedings. So it's going to be out there, and certainly if you then had a discrimination finding at the end of that, it's never going to, reflect well. That's in the public forum and will remain there. Or it could just be through word of mouth if someone's left because they feel they've been discriminated against, things like that. And again, it's not going to look good for anyone as an employer, and also as a general company. A lot of people, in considering what companies they're either going to perhaps deal with as a supplier or a partner, or even as a customer, they will look at things such as that. So yeah, it's very important to ensure that you are sort of compliant in providing that inclusive workplace. So moving on from discrimination, we've got a slide here looking at, so I've got working time, leave, and minimum wage sort of topic. Now this is a very broad area, and again, you could spend a very long time going through all of this, but what we want to touch on, these are some of sort of legal minimum requirements and you'd need to be looking at if you're taking on employees. And understanding these laws is essential for both employers and employees, so you can ensure that especially when it comes to working time, there's a right balance between the work and personal life, and again, ensuring that you're not falling foul of the requirements, because again, there will be legal consequences if you were. So taking the first one here, working time regulations. So the working time regulations is a sort of piece of legislation, the regulations which govern various aspects of working hours. Now that can include the maximum working hours that an employee should be working, as well as things such as rest breaks during their shifts, daily rest periods, so rest periods they've got sort of between sort of shifts each day, as well as weekly rest periods. Now, there's certain categories of individuals that doesn't apply to, but as I say, I'm not going to go into all of that in this detail here. To take a couple of the sort of key items there. So firstly, the maximum working hours. So as Tom said, there's a duty of care from an employer to ensure, a safe workplace is provided, and this all comes into it. And you'd need to be taking reasonable steps to keep, the health and safety of your workers. And this is why there is some working time regulations, and an employee's sort of average working time should not be exceeding 48 hours per week. Now, they can still do that because that, in 1 week, so there was particular demand or need because the measurement of that is taken over a 17-week period. But yeah, that is what the limit is. And of course, there is things such as you can have opt-outs to it. And there is, as I already touched on, there's certain categories of individuals that won't apply to. But that's the key sort of headline point there. Breaks and rest periods. So where appropriate, rest periods of 11 hours uninterrupted should be given essentially per day between shifts, and also 24 hours uninterrupted rest period each day each week in a 7-day period. And then finally, we have rest breaks, on a very much on a daily basis, but during work of 20 minutes if they're working more than 6 hours in a day. There's no requirement to pay an employee during those rest periods. So, for example, this 20-minute work break, there's no need to pay them for it. Rest breaks don't count as time being worked unless your contract specifies otherwise. And I guess to stress, these are the minimum. Obviously, a lot of employers would offer more. A lot of employers, if you've got an employee working perhaps a full day, offer half hour or an hour by way of an unpaid sort of lunch break and things like that. So yeah, these are the minimums. Moving on from the working time regulations, we've then got leave entitlement. So as employees, there's certain types of leave that they're going to be entitled to. And the first one, and obviously the most common one, is annual leave, holiday. Now, we have set minimums again that you're entitled to. And essentially, for an employee, it's 5.6 weeks or 28 days paid holiday per year. Okay. And that's based on a full-time worker. Obviously, if someone's working part-time, then it would be prorated to the same as obviously what the hours essentially they're working. But in terms of when a leave year would commence, that's going to be dependent on sort of what the employer, how I run that. It doesn't have to be any set periods. Obviously, it's commonly same as a calendar year or perhaps whatever the employee's financial year is. And that would be up to you as an employer to be setting. In terms of people who don't work sort of perhaps regular hours, so with the easy example, as Tom touched on earlier, someone like 0-hour workers, they still have that holiday entitlement, okay, at the same level. But obviously, if someone's working very sporadically throughout the year, it can be harder to calculate. But they would still accrue that pro rata entitlement, something that many employers look to do and have historically done, although they historically shouldn't necessarily have been doing, but it is now sort of perfectly okay to be doing, is rolling up holiday. And that's calculating essentially their holiday pay on a percentage basis and including it within their, or in addition to their base pay, rather than giving them the sort of separate time off. And in essence, at 5.6 weeks, it's a percentage of 12.07% you'd be applying. Now, in terms of sort of what can happen, before I move on to the next type of leave, if you were to breach either, the annual leave or any other sort of working hours requirements under the work time regulations, obviously, again, this can lead in legal action, claims against yourself as an employer, reputational damage, and various fines as well. So it's obviously something you need to be complying with. We then have sick leave. Just to touch on that, obviously employees are going to be entitled to time off if they are unwell and sick. In terms of basic sort of minimum requirements, you'd be required to pay an employee statutory sick pay after they've been absent for sort of 3 full days or more. So as of day 4, they're entitled to the SSP. In terms of what the employee is required to do, so for the first 7 days of an absence, they can self-certify, so they can be essentially just informing you that I am unwell, I'm unable to work. But after that, they'll be required to take get a fit note or a sick note, whatever term they're going to use for it. And that's going to come from a medical professional, obviously confirming the dates they're unable to work for. So it might be just signing them off perhaps for a week or a month, and a description of why it is. So be it work-related stress or some form of injury or anything really. In terms of what and as an employer you'd be entitled or required to do, as I say, it's statutory sick pay is the minimum. Again, many employers might offer some form of enhancement, but again, that would be a decision for you to be making. Other types of leave, I'm just very much going to briefly touch on them. Obviously, employees, if they meet necessary criteria, are going to be entitled to maternity, paternity, and adoption leave. And there is a whole host of sort of topics we can be looking at in respect of that. I'm not going to go into each one of them in brief detail, in any major detail. But the key takeaways from it is it's important that you satisfy, and comply with those requirements. The next topic I've got on here is minimum wage. Minimum wage is a prescribed hourly rate that, as a minimum, you need to be obviously paying your employees. They set that at different brackets, okay, and that depends on the age of the employee we're looking at. So by way of example, just to run through sort of the current basic ones, we have it's £5.28 for those who are under the age of 18, £7.49 for those 18 to 20, £10.18 for those 21 to 22, and £10.41 for those over 23. Now, that's obviously going to be the vast majority of the workforce, so that is the minimum rate you'd be looking at. You may have heard the term national living wage. The national living wage is sort of £10.41 as well, but that's a term which is living wage is set by what we call the Living Wage Foundation, which is a campaigning organisation, and they promote a voluntary minimum hourly rate, which should be sort of paid to individuals, and that's calculated based upon the basic cost of living. And as I said, as of now, this is aligned with the sort of top band of the minimum wage there. Those rates, need to be monitored. They go up pretty much about every single sort of April. So if you were to be employing employees under minimum wage, each April you need to be revisiting obviously what they're being paid, or else you'll find yourself inadvertently falling foul of that requirement. Again, just to touch on, what's the consequence if you did fall foul of it? It's enforced by HMRC. They can serve notice for underpayments. They can sort of name and shame a company, and technically there can also be criminal prosecution. As an employee directly, they could also look to bring sort of claims for their wages. So again, it's just not a world you're going to be wanting to enter into, especially not at the outset of this journey. Finally, and the final sort of key topic we want to touch on here is termination of employment. Now, hopefully this isn't what you're looking at this early stages, but it's an essential topic because you don't know where it's going to go as you take on employees. You might face issues with them. You might have need to be getting rid of someone for various different reasons. And it's really important that it's done properly. And there's various ways and reasons you may be looking to terminate employment. And the first and key topic really here is it a fair or unfair dismissal? Now, as Tom explained earlier, an employee gains protection against unfair dismissal once they've been employed for 2 years or more. And at that point, in order to dismiss them, you need to have what we consider called a potentially fair reason for the dismissal. And that can be capability, that could be conduct, redundancy, some other substantial reason, or essentially statutory reasoning. So capability could be something such as ill health, conduct, sort of any gross misconduct. They could be doing something which was sort of really negligent or breach of sort of the terms they've agreed with you. A redundancy, you could be obviously perhaps having to restructure for some reason. It could be that you're cost cutting. And then we have sort of as a breach of statutory duty. This could be essentially perhaps you've got someone that you've taken on under a visa, and their visa is no longer valid, so they don't have the right to work in the UK. That would result in that being terminated. And then some other substantial reason. Now that can cover a whole multitude of topics. And I just want to give perhaps an example. It could be you have an employee who you're essentially outsourcing to a customer, and they're working directly at their premises or something like that, and that customer turns around and essentially has said, we do not want to work with this employee anymore. There's not much, it puts you, as an employee, that would put you in a very difficult position. And if that was the only work and available to them, you might have no other choice but to look to terminate that relationship with the employee. So it's really important, you can't just get rid of employees once, at free will. You really need to consider what the reasons are, especially once they've got that protection at 2 years. So that's sort of looking at unfair dismissal. If the dismissal was not for one of those reasons, they've got more than 2 years service, then there's a potential claim for unfair dismissal. And that's obviously, not where you want to go. If they've got less than 2 years service, it's easier to obviously remove someone. You do not need to have that potentially fair reason for dismissal. It can be for really whichever reason you're looking at, and decide. It could simply be you're just not getting on with them. There are still protections that are there, however, and I just really want to touch on them, because it would be sort of amiss of me not to. Obviously, you can't still discriminate against anyone in doing so, so it couldn't be for a discriminatory reason. And there's also still could be risk of whistleblowing complaints. So if an employee has blown the whistle, perhaps reported a breach of legal obligation, and that's the reason for it, then they don't need the 2 years service to be protected there. So the next claim on the slide is and sort of type of termination here we're looking at is what is a wrongful dismissal? A wrongful dismissal is essentially where it's a dismissal in breach of an employee's contract. Now, the real key focus on that, and the way that normally would arise, is if you breach their contract by not providing them the correct notice or notice pay. So let's say you turn around and decide to, get rid of an employee and dismiss them, and just basically told them to pack their bags and go that same day, and did not pay them any notice entitlements or did not have them work any notice. That employee is going to have a claim, because it's, unless there's certain reasons for it, but it's going to be in breach of their contract. You would not have complied with the notice requirements. And then the final one, and again, Tom touched on this briefly, and said we'd be coming back to it, and is a constructive dismissal claim. And this is where an employee feels they've got absolutely no choice but to resign, on the basis that as an employer, you've done something perhaps that's very serious. It might be a breach. Now, one of the key ways that arises is a breach of the implied terms of trust and confidence. So if employee was being consistently treated, perhaps very unfairly, or you decided one day to sort of absolutely berate them in front of everyone, something like that could breach those implied terms, or it could even be certain breaches of express terms. And an employee might then say, well, look, you've done all that, and I think I'm entitled to treat myself as being dismissed and resign from this. And if they've got 2 years service, they could then bring a potential unfair dismissal claim arising from it. Now, in terms of bringing claims, if an employee has those potential claims, they do have a time frame in which they must take that action. And if it's an employment tribunal, they've got 3 months less a day to bring that claim from the date of any dismissal. That can be extended through what we call ACAS, early conciliation. But it's important to note that an employer is not on the hook if they've dismissed someone. It's not going to necessarily come back and bite them 2 years later. There is a time frame for bringing the claims, and that is to give employees certainty over that. Now, the final topic here we've got is just a bit on notice periods. So I mentioned that under wrongful dismissal, you need to give employees correct notice. Now, notice is usually required to lawfully terminate a contract of employment. 2 different types. You might have statutory notice, or you could have contractual notice. Notice tends to be contractual. So you'd normally have a term in your employment contract which will deal with what notice is required in order to terminate someone's employment. And if that is absent, or perhaps if there is, it's not a very long period of time, there is a statutory notice that can apply as well. Okay, and it will be whichever is the higher is required. So the statutory minimum notice period is essentially once you've worked for more than 1 month but less than 2 years, an employee would be entitled to 1 week's notice. However, after they've been employed for a period of 2 years, they they're entitled to 1 week notice per each year they've worked, up to a maximum of 12 weeks notice. So just as a quick demonstration or example, if you've got an employee who's worked with you for 10 years, but their contract only says they're entitled to 4 weeks notice, it is the statutory minimum that would then apply. They'd be entitled to receive 10 weeks notice in order to terminate that relationship. There's other aspects that can be considered here as well that you might want in a contract. You might want things such as a pylon clause. Pylon stands for payment in lieu of notice. And that would be an entitlement for you to essentially give an employee a lump sum payment of what their notice period would have otherwise been, instead of having them work it. That can be advantageous at times. You might want someone out of the business quicker, and it can be a useful tool to have. So that's it for the notice period section, and also covers off the final topic we were looking at here. So just a final sort of slide, just with there's sort of Tom and my details there. If you have any sort of employment law questions on that, feel free to reach out to us. We also have a contact email for you, where you can reach out if you've got any questions about anything on this webinar, or also about our sort of hub space here as entrepreneurs or startups, if you're interested, and that's hub@hc.law. So I think all that's really left to say is firstly, if there's any questions, do let us know. I haven't seen any pop up in the chat box as we're going as of yet. But as I say, do reach out if you have any following up from this. So otherwise, thank you very much for joining us from Tom and myself. And please do join us on the next sort of WISE session, which will be advertised all in the same way as this one was. Thank you very much.